Well, Nathan and Natalie were told this stems from a complaint by a juror. They felt members of the defense team were being disrespectful towards them. Now, those lawyers have put out a statement saying that was not the case, but given concerns about fairness moving forward, this case will now be heard by the judge alone. A short time after the 5 former members of Canada's World Junior Hockey team arrived to court in London for another day of their sexual assault trial, jurors in that trial were told by the judge that the jury was being dismissed.
It seems something must have happened that involved a jury member that resulted in the jury no longer being able to sit on the case because of their exposure to something that would have made it difficult to have an impartial verdict.
The judge in the case did not inform jurors as to why their services were no longer required, but lawyers for one of the players, Alex Formington, released a statement saying in part, "We, his counsel, found ourselves involved in the unusual chain of events that led to this outcome. In short, a juror came to somehow believe that our courtroom demeanor was disrespectful of her. This was an unfortunate misrepresentation. No defense counsel would risk alienating a juror, and nothing could be further from the truth. In this instance, while it is true that co-counsel will speak with one another from time to time during a trial, this is commonplace. The very idea of counsel making light of a juror is illogical and runs directly counter to our purpose and function. In a larger sense, perceptions and appearances play a central role in this trial, particularly appearances that have been captured on videotape and perceptions about courtroom testimony. If a single juror were prone to leap to unwarranted conclusions and potentially impress these erroneous conclusions on their fellow jurors, the ends of justice and the right to a fair trial would be jeopardized. There has already been one mistrial declared in this case back in April. The decision has now been made to continue the trial in front of judge alone.
An accused has the right to have a trial in front of a judge and jury, and clearly that's what they elected originally. Now, in sexual assault cases, I have to tell you from my experience doing tons of them, we do often judge alone because there are a lot of intricacies about evidence, what's admissible, what's not. So you need to be careful, and judges are generally very adept at dealing with that.
All 5 of the accused have pleaded not guilty to the charges. Now, having the trial continue by judge alone will spare the complainant from having to testify again. She just finished more than a week of testimony and cross-examination. Originally, it was expected this trial could take 8 weeks. That was before the first mistrial was declared. So far, 5 witnesses have testified. At the beginning of the trial, the Crown said there were as many as 47 potential witnesses. Nathan and Natalie, back to you.
Okay, thank you, Scott.